Good morning, everyone. Welcome to the Employment Law webinar. My name is Yvonne Mkefa, and I'm a director in the Employment Law Department here at Cliff Decker Hofmeyer. Thank you for making it this morning and taking time away from your busy schedules. We are confident that this webinar will be of great value to you and your organization, as we will be discussing the proposed amendments to the employment and labor legislation. For those of you who attended our workshops and conferences in 2024, you certainly had a sneak preview of what we'll be discussing this morning. You would recall that we spoke about some of the impending changes that we're seeing unfolding from the deliberations from NEDLAC. Firstly, around July 2024, here at CDH, where the former Judge President Bashir Wegley speaking on decriminalization of the workplace, we now have a draft code of good practice on dismissal, which incorporates this. Secondly, at our slot, we had a specific slot dedicated at our 2024 annual Employment Law Conference on the impending amendments that we were seeing, or we were seeing coming through from the NEDLAC discussions. And this will be touching on again this morning as we discuss with the panel. Over and above the two, we've also seen the NEDLAC report, and it cites one of the aspects in the large-scale retrenchment law, which is Section 189, that needs to be amended. And this comes from a judgment in 2024, which CDH represented SAT, which is South African Airways Technical, against NOMSA when we're defending a large-scale retrenchment. To tackle these amendments, I am joined by a panel of senior associates from our Employment Law Department here at CDH. I'm joined by Terrin York, Lee Masuku, Khodisho Pashe, and Leila Musa. Welcome, everyone. I'm looking forward to the discussion this morning. Perhaps let's start with one of the most important definitions in an employment relationship. Lee, there is a proposed amendment in the LRA, the Labour Relations Act, in the BCA, the Basic Condition of Employment Act, that contains a new definition of an employee. What is this new definition, and what does it mean for employers?
Thanks, Yvonne. The new definition of employee included in the LRA and BCA bills, I'm going to refer to this as the expanded employee definition. What this definition seeks to do is to categorize individuals as employees if they perform work for another person, they provided that the person that they work for is not a client or a customer of the trade or of their own trade, profession, or business. What the expanded employee definition is also accompanied by a definition of employer, which states that a person is an employer where they are an entity or an individual for whom another works. Now, obviously, that is quite a broad definition. The expanded employee definition by itself doesn't make immediate sense. And what this will then lead to naturally is that there will be some kind of legal uncertainty if that definition finds itself within the LRA and BCA in the eventuality of time. However, what the expanded employee definition seems to want to deal with is individuals who render personal services, although not for their own account. The definitions, the expanded employee definition and the employer definition is then accompanied by a presumption of employment, which will make a person an employer unless they can prove certain criteria. So these criteria that an employer will need to rebut all three factors is that the person does not form part of their organization, that the person is not subject to the employer's direction and control in respect of the work that they perform, and that they're also not providing services to customers or clients under terms set by the employer. The purpose of the inclusion of the proposed Schedule 11 to the LRA is to extend the freedom of association, organizational rights, and collective bargaining rights to the specified category of employees. So it's a broader category that will be covered by these rights. Whereas the expanded definition of employee in the BCEA is so that the Minister of Employment and Labour can set minimum employment conditions for this category of employee. This is where the expanded definition of employee for the BCEA only applies to chapters 8 to 10 for the BCEA. So it won't be the full suite of rights contained in the BCEA. What is unclear is why the expanded definition of employee finds itself in a schedule to the LRA as opposed to the definition section of the LRA being updated itself, or even just the definition being placed in the Act itself. This is a slightly different approach to what is included in the BCEA, where the expanded employee definition finds itself in the applications section of the BCEA, so the body of the Act itself. It's also interesting to note that during the NEDLAC deliberations, this expanded employee definition was rejected by organized business, as well as the intention that the Minister of Employment and Labour will have the power to set minimum conditions of employment through a sectoral determination.
Thanks, Lee. So you mentioned the BCA, and we also see that the BCA the bill introduces a concept of an on-call worker. What is an on-call worker, and what would be considered for an employee to fall within this category?
An on-call worker, as introduced in the BCA, is an employee who is required to be available for work and who an employer is required to make work available for. So this category of employee is more colloquially referred to as a permanent casual employee or a seasonal employee. These employees are not, the employees covered by this amendment are traditional employees. So those currently defined in the BCA as employees, so not the expanded definition. This is because this amendment finds itself outside of chapters 8 to 10 of the BCA. It will be included in chapter 2. So this means that in order to be an on-call employee, one first has to be a so-called traditional employee. For these on-call employees, the amendment requires employers to provide written particulars of employment dealing with the maximum hours that the employee is required to be available for work, the guaranteed hours an employee would need to be to work, the period for which they're required to be available for work, the notice period that an employer needs to give in order for an employee to report for duty, as well as the notice period, the notice period for cancellation of any work that's been made available. And this is all to provide some kind of certainty of predictability and fairness for these on-call employees, because what the amendment does is it sets consequences and restrictions where an employer does not give the necessary notice. The amendment also provides that or restricts an employer's availability or restricts an employer's ability to prevent, prohibit, or restrict these employees for working for another employer where they have made themselves available for work as required. This is yet another amendment that was rejected by organized business during the NEDLAC process.
I mean, we see that the law seeks to, seem to want to protect what they deem to be vulnerable employees. I guess that's something that they always look out for. Let's maybe move to Kgodisho. We've seen significant amendments in the LRA. Can you just take us through some of these in relation to the dismissal process?
Sure, thanks, Yvonne. I think we've seen some significant amendments to the LRA, and I think at the heart and the core of these amendments is the fundamental principle of fairness in dismissals, and this remains a cornerstone of our labor law framework. The proposed amended LRA continues to emphasize that the code of good practice must be considered when determining whether a dismissal is procedurally fair. Now, we'll delve deep into the implications of this code of good practice a bit later. However, I'd like to draw your attention to a particularly noteworthy amendment, which is the proposed section 1883. Now, this amendment seeks to explicitly clarify procedural fairness by stipulating that unless otherwise agreed upon in a collective agreement, a fair dismissal process must afford the employee a reasonable and adequate opportunity to respond to the reasons that may be put forth for a dismissal. Now, this is interesting because it codifies the long-standing audi alteram partem rule, which simply means let the other side be heard. And this is a fundamental way to secure procedural justice. Now, by reinforcing this principle, the amendment moves away from the excessively rigid and adversarial pre-dismissal procedures while ensuring that employees are granted a fair opportunity to be heard. Now, that's one of them. Another key amendment which affects dismissals is the proposed section 1884, which follows after the one that I just mentioned now. And it introduces specific provisions regarding new employees' protection against unfair dismissal. Now, this is very interesting because under this provision, the protection against unfair dismissals will not apply during the first 3 months of a new employee's tenure or any longer probationary period, provided that it is reasonable and operationally justifiable in terms of a contract of employment that may exist. Now, it is crucial to note that these employees will still be protected against automatically unfair dismissals, right? Such as those based on discrimination or other prohibited grounds. This amendment, at the core of it, actually considering the submissions that were made during the NEDLAC process, aims to encourage employers to take on new talent, particularly young individuals entering the workforce with little to no experience, by reducing the immediate risks associated with potential unfair dismissal claims. The provision now balances the need for businesses to assess an employee's suitability for the role while maintaining the core protections for such a business. Now, one more that I'd like to deal on before you move on, Yvonne, is the insertion of section 1152, which deals with the functions of the CCMA. Now, interestingly, under this provision, the CCMA will be empowered to assist employees in enforcing arbitration awards granted in their favor. Now, this is obviously a big one, as this assistant may include the payment of sheriff costs. And I know you're probably wondering how is there going to be any financial provision which is made for this and how exactly is this going to work? But while the practical implementations and financial feasibility of this provision remain unclear, its intent is commendable. It underscores a broader legislative shift towards strengthening protections for the most vulnerable workers, ensuring that whenever they get an arbitration award which is in their favor, the CCMA can still assist them in enforcing that. So it takes the CCMA's assistance and it just broadens it.
Thanks, Felicia. Yeah, I mean that as you say, that's just commendable because it's, as it were, the matters just lie dormant for a while because some of these arbitration awards may not have been pursued or been enforced and so forth, or in some instances, even the review applications are not pursued. We'll see how this actually panned out. Leila, we've just talked about changes or amendments or proposed amendments to the insofar as dismissals are concerned. Are there any, or maybe just take us through any proposed amendments in relation to unfair labor practice?
Sure, thanks, Yvonne. So in the form that the LRA is currently drafted, there is in fact an existing closed list of what constitutes an unfair labor practice. So while the definition starts off by saying at 186.2 that an unfair labor practice means an unfair act or omission that arises between an employer and an employee, it involves certain closed lists, right, of categories. And those categories, as we know, include the unfair conduct of an employer relating to promotion, demotion, probation. Then there's unfair suspension of an employee or disciplinary action that's short of dismissal. Then there is the failure or refusal of an employer to reinstate a former employee in terms of an agreement. And then lastly, any occupational detriment other than a dismissal that relates to a protected disclosure. Now, that's a closed list. So what the proposal is that there will be the removal, or it's proposed to remove what was at 186A and 186C. Now, those two categories of unfair labor practices are those that relate to the promotion and demotion and probation, and then also that failure of an employer or refusal to reinstate or to reemploy a former employee. And the impact of that is that as unfair labor practices, what remains as the justiciable there would be limited to any unfair practices, unfair labor practice disputes that relate to unfair suspensions or any unfair disciplinary action short of dismissal, and then also those unfair labor practices that relate to protected disclosures, i.e. protected whistleblowing.
So practically, we are so used to this closed definition and categories of unfair labor practice instances and disputes and how the CCMA and the courts have dealt with it. So practically, what are the implications of these amendments vis-a-vis the employee rights to pursue disputes that relate to promotion, demotion, probation, training and benefits, and as well as the refusal to reinstate or re-employ former employees?
Yeah. Thanks, Yvonne. So that's unclear at the moment. From what we're seeing in these proposed amendments, there isn't a clear alternative to how employees would pursue these kinds of disputes. What, in our discussions, what we've kind of identified as what's left for employees there is that they may be required to limit those disputes to those that arise out of their contracts of employment or their terms and conditions of employment otherwise. And that begs the question to note, what does this mean for our courts? What does it mean for the kinds of disputes that we're going to see in the CCMA? Are we going to see an increase now in matters that are going to be taken to the Labour Court and that are going to have to be adjudicated there, whereas perhaps we would have seen, increases of, or the potential of having matters resolved at conciliation if they were referred on an unfair labour practice basis to the CCMA?
Thanks. With amendments, I think the last thing you need is a level of uncertainty, but that's where we find ourselves. And I think in our discussions and things that unfold, we'll also be able to update clients and also interested parties on how these will be navigated. Maybe then let's move on to amendments in relation to large-scale retrenchment processes. Taryn, what are these amendments, and what does it really mean for employers as well?
Thanks, Yvonne. So one significant amendment transfers the authority to establish facilitation rules from the Minister of Employment and Labour to the CCMA in order to ensure a more streamlined and independent approach. Further proposed changes are to the process for challenging procedural fairness in large-scale retrenchments. These include amendments which will no longer allow urgent applications to challenge procedural fairness while the retrenchment process is still ongoing, meaning that any challenge to a procedure can only be made after the retrenchment has taken effect. Additional subsections will be amended to enable that all aspects of the retrenchment process are also only be able to challenge them after the dismissal takes place.
So speaking about facilitation, if a retrenchment process was facilitated, can the dispute over procedural unfairness be referred directly to the Labour Court?
The current legal position is that it cannot be referred directly to the Labour Court. Even if it's facilitated, it still has to be referred to conciliation at the CCMA first. However, the amendments seek to amend this position by providing that where there has been a facilitated consultation process, a dispute concerning the fairness of a dismissal can then be referred directly to the Labour Court without first having to be conciliated.
Yeah, I saw part of this, I think, in the NEDLAC report, where I think the parties were also not at Edom. They were not agreeing on the process, but it seems as if that the proposed amendment has taken a position on this. Are there any intended amendments to the amount? I mean, this has been something that has been making the rounds. People have been debating about the severance pay payable to employees when they get retrenched.
Yes, there is a proposed amendment which seeks to increase the statutory minimum severance pay payable to employees who are retrenched. And this amendment seeks to amend the position from 1 week's remuneration for every completed year of service to 2 weeks remuneration for every completed year of service. The amendment seeks to provide greater financial security for those employees who are retrenched.
Thanks, Terry. Maybe before we move to the amendments to the Code of Good Practice, Kodisho, can you just you touched on the dismissals. What are the key amendments to the dismissal remedies in relation to high-paid employees?
Thanks, Yvonne. So as we've discussed earlier on, that the CCMA and rather let me just say our entire legal framework regarding labor law is intended to just simplify processes, because labor and work in itself is something that should be simplified, because it's something that employees do on a day-to-day basis, right? So our forums would be overwhelmed with disputes if the legislature does not step in and try to alleviate some of these pressures. Now, one of the most significant proposed amendments, in my view, is the introduction of Section 193(2)A, which fundamentally changes the approach to remedies for high-earning employees in dismissal disputes. So we understand that we have persons that are protected based on how much they earn in terms of the BCEA. However, this introduces what we call a high-earning employee. Now, you may be asking yourself, what is that high-earning employee? And how will that be determined? The initial proposed threshold for such a high-earning employee is set at 1.8 million per year. So that's somebody who earns 1.8 million per year. And obviously, this would be adjusted annually from the 1st of May, according to the CPI. Now, according to this proposed amendment, high-paid employees will only be entitled to reinstatement in cases of automatically unfair dismissals. And this is why I start off by saying it's such a significant amendment, because again, I'll repeat it, high-paid employees will only be entitled to reinstatement in cases of automatically unfair dismissals. In all other unfair dismissal cases, reinstatement will no longer be an available remedy. Instead, affected employees, which is this high-earning person, will be limited to capped compensation as their primary recourse. Now, a compensation award in this regard will also be limited to the high-earning threshold, which will be prescribed by the minister. Again, as I mentioned, it is 1.8 million. Now, this cap does not apply to automatically unfair dismissals. Now, what are these amendments trying to create? Now, this amendment reflects a policy shift aimed at balancing employees' rights with businesses' operation requirements and ensuring that high-paid individuals or high-paid employees who are often in senior positions do not prolong disputes through reinstatement claims that may not be practical or desirable for employees. Now, while ordinary unfair dismissal cases will have compensation limits. Employers still face significant financial pressure in cases of automatically unfair dismissals, such as those based on discrimination.
Thanks, Kodisha. I mean, while you still have that is a significant shift, and I'm sure we would see even the pressure on the system lessening, and without necessarily prejudicing employees who are high earners. While you still have the mic, Khadisha, you spoke about, you mentioned the code of good practice on dismissal earlier on, and you also mentioned briefly on the Audi principle, which is important. Can you elaborate, particularly in relation to the decriminalization of the workplace, and what does that actually entail, as proposed by the draft code of good practice on dismissal?
Right. The code of good practice on dismissals simply serves as an interpretive tool, right? It's there to assist employers, employees, trade unions, adjudicators on how legal practices, or rather legal principles, should be applied in practice. So it takes all of these concepts and just principles from the various legislation and puts it in a easy to understand language and in a very, very practical form. Now, what it also does, especially for small employers, it recognizes the unique challenges that is faced by smaller challenges by allowing for a more flexible approach in how these principles should be implemented or practiced. And just to speak on disciplinary matters and just isolate that issue, ensuring that this issue is flexible, this will mean that smaller employees will have to, or rather smaller employers or businesses will have to not follow an adversarial and rigid approach when it comes to disciplinary matters. Now, the code of good practice, the proposed draft code of good practice does not define what a small business is, right? However, we can differentiate between a business which is large and one that is small. Now, one thing to emphasize is that the code of good practice is not a substitute for disciplinary procedures, nor does it override any collectively agreed upon disciplinary processes between employees and employers, or employers and trade unions. Instead, the code will most apply in situations where either no agreement exists on the disciplinary procedure to be followed. But to a key principle underlying this code and its disciplinary processes that it speaks to is fairness rather than criminalization. Disciplinary inquiries should not mirror criminal trials at all, and employers should avoid adopting a very formal approach. Now, obviously, we've had cases in our law, such as the Avril Elizabeth Home for the Mentally Handicapped case, where the Labour Court stressed that the LRA envisions an informal and efficient disciplinary process, and that pre-dismissal procedures need not be overly formalistic. Now, that case is a 2006 case, and despite that case, many employers have failed to move away from this rigid disciplinary processes, and a continued criminal law approach persists, where charges are often drafted in a manner resembling formal charges or indictment. Now, the Labour Court continues to try and emphasize this point, and was further emphasized in the EOH Abantu case that had to do with how charge sheets are drafted. And the court simply stated that employees or HR personnel, internal business personnel that deal with those disciplinary processes are not lawyers and should not be expected to draft charge sheets like charge sheets that are drafted in a criminal indictment. So I think just to close this off, we can see that the purpose of the Code of Good Practice is simply to simplify the law and ensure that the layperson, the everyday worker, can read this Code of Good Practice and can understand it so that they may have access to justice. Thanks.
Thanks, Thodisho. So I think the draft code also mentions words such as have dialogue and have time to reflect. And as you say, it's the language itself is meant for everyone to understand that the process, the internal process itself, is not a court of law. It shouldn't mimic it, even make it also easier for employees, because those processes can also be overwhelming, while employers and their representative and managers may be familiar with those processes, but sometimes it just gets too overwhelming for employees. And I think the code seeks to strike that balance to say that the process itself need not be too formalistic. And further, that it also need not be long. Because if you are having a dialogue, you're actually trying to establish the facts so that a determination is made as soon as possible. Thank you so much, Khadish, and also just to give us the understanding of what is the role of the codes in the world of work. And I mean, we also have seen that internally, when these processes are undertaken or attorneys have been appointed, I think the responsible thing to do, I think, as attorneys, is to adhere to the principle of not be formalistic. I mean, the minute you hear splitting of charges, you must just see red flags, because that's exactly what lawyers would do in these cases. Before I actually take up much of our time, maybe let's just move to another concept that is, or amendment that is raised in the draft codes. And this is for you, Lee. How does the draft code of good practice deal with issues around inconsistency or consistency? We know that often inconsistency is a common defense that is raised by employees in disciplinary processes and sometimes in post-dismissal disputes.
That's correct, Yvonne. Generally, the rule is in employment law is that there must be the consistent application of disciplinary sanctions. And because of this, there's been somewhat of a trend over the years that employees will raise inconsistency as a defense to the allegations put against them or to the ultimate dismissal itself. So what the draft code does is that it introduces a provision that sets out that even where there's maybe past inconsistency in the application of discipline, a dismissal can still be effective if the continued employment relationship has become intolerable. And this approach is consistent, and excuse the pun, with the approach that our courts have taken over the years, that the inconsistent application of discipline is not an absolute bar to dismissal, particularly in serious cases of misconduct.
Thanks, Lee. There's a phenomenon that has also been absent in the code, or actually in law, but we've seen it developing in terms of jurisprudence, and in some instances employers put them in their policies, and this has to do with incompatibility. This, as I said, this is new. What does the draft code say? I think they mentioned the incompatibility, and what does this mean for employers?
That's correct, Yvonne. So incompatibility is not currently contained in the LRA as a ground for dismissal, but over time it's been defined as an employee's inability to relate to their colleagues or to the employer, and has been generally treated as a form of incapacity. It sometimes has been treated as a form of misconduct as well, where an employee, has the incompatibility results from an employee's own conduct. So what item 21.7 of the draft code does is that it introduces incompatibility as a form of incapacity defined as an individual's inability to harmonize with an organization's culture or one's colleagues. So this then acknowledges incompatibility as a form of incapacity in relation to a potential dismissal.
Thanks, Lee. I mean, as you say, that there's been varying ways of how incompatibility has been dealt by both employers and in our courts. And I think this will also just assist in shaping that jurisprudence with precision and create some certainty. Leila, let's just maybe move to dismissals that are linked to strike misconduct and how to deal with collective hearings. What does the proposed amendments in the code address the concepts?
Yeah, thanks, Yvonne. So it's quite interesting to see that now the draft code of good practice includes a section that specifically deals with dismissals that are related to industrial action. And what the section confirms is that a strike that does not conform, or participation in a strike that does not conform with the requirements of Chapter 4 of the Labour Relations Act, so that will be the provisions that relate to strikes, it amounts to misconduct. So that is now in the draft code. And what it does is it takes it further, and it actually sets out the factors that an employer may use to determine the substantive fairness of a dismissal. And these factors include the seriousness of the contravention, which now has a further list of factors, attempts made to comply with the Act, and therefore the provisions that are set out in that Chapter 4 of the Labour Relations Act, and also whether the strike was in response to an unlawful, unfair, or unreasonable conduct of the employer. So from a substantive aspect, what we're seeing there is that there is a focus on the actual unprotected strike, right? And the employee's participation in that, and that substance itself would then amount to misconduct. So it alerts us to the fact that from an employer's perspective and in establishing the substantive fairness, you would do well in if this draft code is given effect to ensure that it is clear to employees that these are the reasons why the conduct that you're embarking on amounts to a strike that does not comply with the provisions of the LRA and is therefore unprotected. So in emphasizing that, you are forewarning and ensuring that employees understand substantively why it's a problem that they are participating in it, and therefore why it would be a problem that they then or why it would then amount to misconduct. So that's from a substantive perspective. Then there is the procedural aspect, which, as we know, is required for the fairness of all dismissals. And the draft code then sets out the process before dismissal in relation to strike misconduct or participation in an unlawful strike. Of course, there's the separate matter of misconduct in a strike generally. And here what it's saying is that as a first step, where there is a strike that does not comply with the LRA, an employer should engage at the earliest possible opportunity with the trade union in some kind of dialogue to say, this is why on a substantive basis, this strike is unprotected, it does not comply with the LRA, and these are the possible consequences. And get the trade union to then engage with Labour, with the employees, to allow them to then understand what the situation is from a legal perspective and the possible consequences. And therefore, after that, once they've had that engagement, then re-engage the trade union and allow them to make representations to you, give them that opportunity to engage, to explain why they, as the trade union, why the employees then with them are taking those particular actions. Now, if there's not a trade union involved, then it would be a matter of the employer trying to engage with the relevant employees and possibly certain employees who may be leading the strike action. And where that engagement, that initial step one engagement, does not resolve matters, employers are then encouraged to issue the employees with an ultimatum. And that ultimatum should be in clear and unambiguous terms to explain what do you as the employer require those employees to do in order to comply with your ultimatum, and what sanction will be imposed if they do not comply with the ultimatum. And typically this means saying, this is an unprotected strike. Please return to work by 9 a.m. tomorrow. Failure to do so may result in disciplinary action up to and including your dismissal. And how many of those ultimatums we take, what our time periods are like, would depend and differ from employer to employer. So you need to make sure that you're giving them sufficient time, given the extent of your operation, number of employees, etc., for them to reflect on that ultimatum and respond and decide whether or not they comply. The provisions of the draft code also explain and say where an employee or a number of employees then do choose to comply with that ultimatum. So they've heard you, they're engaging with you, and they're choosing to come back to work, and they're showing some compliance. It is not necessary. It's not necessary then, and an employer should consider: do we then still pursue the misconduct in relation to their initial participation in the unlawful strike, or do we accept and say, okay, we're going to move forward positively now, they have complied, they've showed engagement in a positive sense, it's the kind of thing that we like to see in our workplace, and we're going to move on from there. If they, of course, do reject that ultimatum, and again, it might not be one ultimatum, it may be necessary to do more than one depending on the circumstances, employers may then choose to then dismiss the employees for their conduct and in accordance with the provisions of this code. Now, before that happens, and this is where it's interesting that we're seeing this in the draft code, there needs to be that further opportunity, or it's encouraged that there's a further opportunity for a right to be heard, that Felicia spoke about earlier. And to give them that Audi, what the draft code is saying, that it may satisfy that Audi alteram partem or right to be heard requirement if you ask for collective representations and effectively conduct a collective hearing, so to speak. But it does say, in certain circumstances where this is not possible, and it may not be possible in all circumstances. We've seen these strikes in many workplaces where it's simply not possible to engage in this way. Then an employer may, in fact, forego certain of these procedures that set out what is the desired or the envisaged procedural fairness requirement for a strike dismissal.
Thanks, Leila. I mean, you've touched on the practicalities as you were explaining the draft. Is there anything else that you need to add in relation to these collective hearings, or can we then just move to the to the next issue on operational requirements? Is there anything else that you would like to add?
Thanks, Yvonne. I think just the one short point is that in relation to the collective hearings, and we've seen this in our recent case law in the Labour Court as well, employers should make considered efforts to ensure that they are properly identifying employees and they're in a position to properly note which employees are in fact complying with ultimatums and which employees are still perhaps rejecting that ultimatum and persisting with an unlawful strike. And that will be critical to ensuring that you are giving not only from a substantive perspective, but from a procedural perspective, those employees have been notified by whatever collective means they've been called on to make their representations, and therefore the procedural fairness of their individual dismissal would also be covered by that collective representation or collective hearing, so to speak.
Thanks, Leila. I mean that those strike-related processes have actually been quite, I think, critical, and in some instances we find that it's just really at the end that the employers are unable to sustain those decisions and they get overturned. And as you would note, that it's a number of employees, and then when they are reinstated, it also just causes a bit of a not only just an inconvenience, but it really impacts the operations, and employers find themselves in a very precarious position. So it's actually critical that as you deal with the strike and as you give the employees an opportunity to adhere to ultimatums, and you keep a good of who is there and what they're doing, so that you also identify people who did not, or continued to misconduct themselves or being in an unprotected strike. So that is actually of great really thanks. Taryn, the code also touches on amendments, or the amendments in relation to dismissal for operational requirements. Can you just tell us what are the significant ones that you'd like to share with us?
Sure. Thanks, Yvonne. So operational requirements have now been integrated into the code. Previously, they were addressed separately. The code also introduces an Annexure A to the code, which details the format for the Section 189.3 notice. So the notice includes the ordinary issues that are required in terms of the Section 189.3 notice, in terms of the Labour Relations Act, and it will streamline the act. It will act in order to standardize the approach for all Section 189.3 notices.
Thank you so much. I also note that the questions that are that have been posed on the chat, and I mean we've also have our panelist responding there too. Lee, I'm wondering is it possible for you just to voice over that one in relation to discrimination and harassment before we close the webinar?
No, not a problem, Yvonne. So the question was posed in relation to how commissioners would deal with issues of discrimination, given that it's now falling within the CCMA's jurisdiction, regardless of one's income. Parties need to be cognizant of the fact that a commissioner will be limited to the evidence presented by a party. So where parties seek to have dividing lines in what does or does not constitute harassment or unfair discrimination, that needs to be clearly set out through the evidence presented through witnesses as well as the documentary evidence. It might also assist parties to limit or to draw a commissioner's attention to the issues that they are required to determine by way of the conclusion of a pre-arbitration minute.
Thank you so much. And I see that there are the questions have also been posed, have also been responded to. And a copy of this particular webinar will be made available to all the attendees, and we've also prepared an infographic that outlines these reforms, which we will be circulating. I'd just like to thank everyone who attended the webinar, and to the esteemed panel that assisted navigating the changes and the amendments to the employment and labor law legislation. With that in mind, I would bid everyone farewell until our next webinar. Thank you so much.